Now we will see May 2017 CA final law paper analysis. See the first question, according to me, see I have seen the question paper. It took me almost 45 minutes to read the entire question paper. To read and understand the entire question paper, not writing the answer. To understand exactly what they asked, it took me almost 45 minutes. I am talking from the normal point of student, normal student's point of view. It will take 45 minutes for the student, okay? Unless otherwise, you are very good, very expert to the subject. For expert also, it will take at least 30 minutes, okay, to understand, to read and understand the question paper. And it's almost 15 pages question paper. So it's like almost a mini booklet. So 15 pages it is. It is very difficult for a student to read 15 pages, a theory. See, it is not even a problematic sums where you are given a sum portion. Yes, sums and all, if you given a big thing, yes, it will take. But a theory, 15 pages you have to read. And it's like, yes, 1.5 line spacing. So if you shrink, it will come approximately to 8 to 9 pages. 8 to 9 pages is also difficult to read in 15-20 minutes and all. It will take minimum 30 minutes to read. Okay. Now the first question, 1A. I can see this first question, that is compulsory question, has been divided into 4 marks. Yes, it may be expected only, but the thing is, little lengthy things are there. Okay. Now, anyone who answered 100 marks of this question paper is great, because 100% satisfaction with 100 marks, a person, according to me, it's very difficult to answer from a student point of view. Okay. See, because so many questions we don't know from where they have asked itself. Means it's not a straight question. Full question paper is for case study kind of question. And previously, yes, case study will be there. But I will tell you, when you are discussing, I will tell you what are the questions which is very difficult to answer perfectly. Okay. Now the first question will go, a company having paid up capital rupees 65 crores, okay, appointed a chartered accountant as a CFO. A company also has a CEO, and this person wants to appoint internal auditor. Can he appoint internal auditor? That is, can this CEO appoint the internal auditor? Point number 1. He is actually wants to make the CFO himself as an internal auditor. Now what is the question? The company is having 65 crores. Now the question is about internal auditor. Now the company, if it's a public limited company, if the paid up capital is more than 50 crores, that is turnover 200 crores or more, okay, outstanding loans more than 100 crores, paid up capital 50 crores or more. So it is 65 crores, hence internal auditors must for a public company. For a private company, just only first 2 conditions is necessary. Second, according to section 179, internal auditor has to be appointed by the board of directors, and it is to be recommended by the audit committee. Since the paid up capital is means like a paid up capital is 65 crores, that is 10 crores or more, obviously the company will be having audit committee also. So point number 1, audit committee has to recommend to the board of directors, and board of directors under section 179 has to appoint. The board of director cannot delegate the power, okay, generally for appointment of internal auditor to CEO. Point number 1, because in delegation of power they are given only for borrowings, okay. So only those things they have been delegated the power. Borrowings, investments, then loans and advances, that is granting loans and advances, securities. Only for this they have given permission. Now they have not given permission for what? Appointing internal auditor by delegation. So the board of directors has to appoint. Point number 1. Point number 2, yes, internal auditor can be 3 persons, either a chartered accountant or a cost accountant or any other professional as the board may thinks fit. In this question, they are asking whether a CFO can be an internal auditor. Now again, CFO is an inside person. Okay, whether internal auditor requires independence? No, internal auditor does not require independence. So CFO can also be an internal auditor. This is one point of that question. So CFO, who is a chartered accountant, can be appointed as an internal auditor. This is the answer for that point. So this question talks about section 138. Okay, so you should answer from section 138 point of view. So you should write applicability and appointments point and whether he can be appointed. Then the next question, company appointed additional director on March 2017. before AGM. So additional director got appointed under section 161(1). Due to natural calamity, the company got destroyed, and with the permission of ROC, they are extending the AGM. Now comment the status of the additional director. Under section 161(1), the additional director has to vacate the office, the date on which the AGM should have been held, or the last date on which the AGM should have been held, or the actually held, whichever is less. Correct? Now, whether they are getting extension or not, he should have been vacated the office, the last date on which the AGM should have been held. So he has to vacate the office. He will not continue in the office even if the AGM is getting extended. Understood? That is a point to be noted. So according to me, this question is easy. Then, listed company has 7 directors, out of which 3 independent directors and 4 directors. 1 director and 1 independent director vacates the office. How to fill the vacancy? This is the question. See, this is called vacancy filling. That is 161 subsection 4. But tell me, 161 subsection 4 is applicable only for the director who is appointed in the general meeting under section 152(2). Now, if the director is vacated the office, okay, under section who is appointed under section 152(2), that is a general meeting director, if he vacates the office, yes, you can replace him. If the general meeting director is vacating the office, yes, you can replace him. Under section 161(4), you have to pass a special resolution, board resolution. 161(4), you have to pass a board resolution and you can replace him. Now, independent director is also vacating the office. In case of independent director vacates the office, as per the rules of independent director, within 3 months or next board meeting, whichever is later, within that time you have to appoint. Independent director and movement director, we studied that, no, within 3 months or next board meeting, whichever is later, you have to appoint a person. So the board of director has to appoint in that scenario. So according to me, this question is also not so difficult, it's easy only. Then, the company, in their pre-booking of sales, this is a very tricky question. So 1D is a tricky question. It's from Competition Act. The company collected almost equivalent money of the product along with taxes, cess, etc. as the pre-booking charges. Now, whether it is unfair trade practices or not, this is the question. Now, the answer for this question, for unfair trade practices. So, the complaint has to be lodged with CCI, that is Competition Commission of India. Competition Commission of India will take assistance from Director General. In case the Director General has been satisfied that yes, there is unfair trade practices, then the Director General will penalize the company. What is the penalty? 10% of the turnover. Okay, they can put penalty. So this question can be answered like that. But I am not sure this is the right answer or not, because we have to see the ICAI suggested answer, which they will be releasing at least 2-3 weeks before the release of examination result. So this question is a difficult question only. Okay. Then 1E, the company wants to make a rights issue. One of the director is categorized as a willful defaulter by RBI. This is from SEBI. So in SEBI, prohibition of issue of prospectus for collecting money, public issue, either through rights issue or IPO. In case if the promoters are willful defaulter, the promoters are categorized as willful defaulter. So what is willful defaulter? This person has not paid the bank dues for a period of 6 months, okay, or he has not paid the public finance institution, etc. Then he will be categorized as willful defaulter. If the company has removed that person, because in this question it's not seemed to be a promoter, so either if a person is a promoter or the person who has been controlled by the willful defaulter, the prohibited person, they cannot issue securities. Now this company, it's not said that it has been controlled by this director. Now if you remove this director, they can go for public issue, but if you keep the director in the board of directors, then you cannot go for public issue. So what you should do, you should remove the director and go for public issue. So otherwise SEBI will not allow. So with this we completed the first compulsory question. Then, so this question, the SEBI question also fairly easy only, it's not difficult. Then 2A, company declared dividend warrant dispatched to all the shareholder except 3. Since they have title dispute, actually what happened, the company has to dispatch the dividend. the company has dispatched a dividend warrant within the 30 days, said 30 days under section 123. But there is a title dispute between 3 shareholders, so the company has not dispatched the dividend to that persons. Then, of the balance shareholders, few didn't encash the dividend. So, the company after 30 days they have to transfer to what? Unpaid dividend account. So, within 7 days they should transfer to unpaid dividend account, separate account. Explain company how to deal with unpaid dividend account and what are the consequences if they have not paid. So, if they have not paid, 12% interest has to be charged. That means what? From the unpaid dividend account they have to transfer to means like from the dividend account they have to transfer to unpaid dividend account. If they have not transferred, they have to charge, means like 12% interest has to be paid in per annum basis, simple interest, and it will be given to the person who has not claimed the dividend. So this is easy question. And another part of the question, that is there is a title dispute. So for the title dispute persons, you have to answer with section 126 and 127. 126 is what? Abeyance. The company has to keep that in abeyance. And 127, if there is a dispute and if the company is not paying that dividend amount, there is no penalty for it. Okay. So no penalty for the directors. Otherwise, in other case, 18% interest they would have charged and director will be imprisoned and penalized. No, that is not applicable here. This is a fair easy question, and this is 8 marks question. It's a laddu, I can say. It's a laddu. So since you may lose a 4 marks in the competition question, you can gain, okay, approximately 6.5 marks you can gain in 8 marks question. So you have to write section 124 in full, then section 126 and 127. Because it's an 8 mark question, you have to fill at least 2 pages, no? Then 2B, director who vacates the office 2 years back not handed over the possession of the flat allotted to him. So this question, it's wrongful withholding of property, which is penalties chapter 452. So a wrongful withholding of property which is given to him at the time of directorship. Now any person who is doing like this, he will be penalized. Now in this question, he has let it out the fat, whatever the flat is wrongfully withholding, he has also let out the fat, okay, and he gained 22,500 rupees as rental income. So this person has to be penalized under section 452. So you have to write the 452 penalty, okay. So you have to surrender the property and the gain you have to surrender, and this person will be charged with penalty. So you have to write that. Then this is also fairly easy question only, but the only thing is the penalty amount has to be mentioned. So according to me, maybe even as applicable under section 452, if you answer also, they will not reduce so much. Okay, this is a 4 marks question. Then the next question, 2C, resident wants to be joint owner of the flat which is going to be purchased abroad. So a flat is going to be purchased abroad, so it's a capital account transaction. But there is no money outflow from India to abroad. But even then, it's like a gift. So it's a permissible transaction because you are a joint holder. Indian can get a gift from a person resident outside India. That is not a problem. So it's a permissible transaction, capital account transaction. Permissible capital account transaction. Then the next question: can an exporter get advance payment for the goods which he is going to export? Yes, advance payment can be obtained. Advance payment can be obtained provided the goods are getting exported within 1 year from the date of advance. If not, you have to get the RBI permission. In case if you are getting advance and the advance as per the agreement carries a interest, it is maximum can be LIBOR plus 1%. Okay, they will say 1% as 100 basis points. They will say like that. Then next question. Can a director be treated as MD? This is third question, 3A. So according to me, 2 is also easy question. Then 3A, can a director be treated as MD by the activities which he is entrusted to do so? What is the procedure for appointing an MD? Now, this question is from 196. So if the public company wants to appoint an MD, they have to pass a board resolution and it has to be ratified by the general meeting to appoint a MD. Merely because of the activities the person is doing, you cannot categorize him as a MD. So under section 196, since this question is an 8 marks question, it's an 8 marks question, so we have to write 196 in detail and 203 also. So 196 we can write a person can become director by passing a resolution, but minimum age, that is 21 and 70 years of age, and you can fix the remuneration as specified under section 197. And the managing director can do all the activities which has been entrusted by the board of directors. The board of directors can delegate the activities. Okay, under section 179, we studied certain activities of the board of directors. The board of directors can entrust certain activities by delegation to the managing director. See, since it's an 8-mark question and the question is very simple, we don't know exactly what they are expecting from the answer. Okay, because 196 is very simple and the answer is also you can write in 2-3 lines. See, what is the procedure for appointing MD? A board resolution has to be passed, general meeting has to be ratifying, or you can directly pass a general meeting ordinary resolution also, you can appoint him. So minimum and maximum age, and the director can be maximum period of 5 years, and he can be reappointed also, that's not a problem. Then if you want to appoint more than 70 years of age, you have to pass a special resolution and justification has to be given. So this is what you can write, but 8 marks is too high for this question. Then a director intentionally file false document, this is 3B, and he has filed returns to ROC. What is the penalty? In case if a director files a false document, this is section 448, it's from a penalty chapter, again from the penalty chapter. So false document if you file under section 448, they are saying whatever penalty you are going to pay under section 447, the same is going to come here. So officer or auditor who is given a false statement, 447 penalty attracts. So if the public is getting affected, if the public is not getting affected, if the public is getting affected, 447 if the public is getting affected, minimum 3 years imprisonment. If the public is not getting affected, 6 months to 10 years imprisonment. This is section 447. That thing you should write here. So it's a fairly easy question only. Then a bank acquired a property from a defaulting person. Can the bank retain the property permanently and earn interest, means like rent from the tenant? See, under the Banking Regulation Act, non-banking financial asset can be held by the bank. That means what? Securing from the NPAs. Non-banking financial asset can be held maximum period of 7 years. And if you want to extend some time, you have to go to RBI. Further 5 years period can be extended by the RBI's permission. In this question, they want to retain it permanently. So the answer is no. They cannot retain the property permanently. That is the answer. So this is also an easy question only. Then 4A1. So as of now, what question I told difficult? Competition question. So competition. And another is MD. 8 marks question, no? It's tricky. So we don't know exactly what they want in this question. Then 1A, what question you told? 1A I didn't tell nothing. Next one. So we are in which question? 3A. Then 4A. Yeah, company wants to remove an employee of the company during the pendency of the investigation, and they have filed a petition on January 3rd, 2017 to NCLT, and NCLT is silent. So the company has removed the person on 15th February 2017. Now this question is section 218, inspection investigation. So during the pendency of investigation, if you want to remove the employee, should ask the permission from NCLT. And NCLT within 30 days has to give permission. If the NCLT is silent, if the NCLT has not told yes or no, then after the expiry of 30th day, the director can remove. So in this question, they have removed after the expiry of 30 days because 3-1 to 3-2, 30 days is over. Now they removed. So there is no penal consequences in this case. Then next question. During investigation, it is found that the director of the company is acting on the instruction given by the holding company. What is the inspector can do now? Now this is question from 219. So there is holding means another company, that is what this is, related parties. So the investigator has the right to do investigation on the related parties also, 219 related party investigation. So which is came in this question now. So the investor has the right to do investigation on the related party, that is the answer. Then the next question 4B, procedure for changes in DIN particulars. See, DIN can be submitted in DAR 3 and 4 form, and DIN particulars can be changed in DAR 6 and 7 form. 6 and 7 form has to be submitted along with the changes in particulars, that's all. Then the next question, director resigns, he filed DAR 11, but the company has not filed DAR 12. What is the status of the director? According to section 168, the director can resign by filing application letter, the resignation letter, and along with he has to submit a DAR 11 within 30 days to ROC. If it has done, he has resigned. But the company has to file DAR 12 to ROC within 30 days from the approval. If the company has not filed, it is not the duty of the director. Once the director has filed, the director is done with his duty. So, but actually, practically I will tell you, in the master data, no, unless and until the company files DAR 12, from the master data, the name will not be removed. But actually, the director will not have any consequences in this area. So, this director is resigned once he filed DAR 11. Then 4C, punishment under PMLA for drug smuggling, opium. See, what is punishment for PMLA for drug smuggling? 3 years to 10 years is the imprisonment. It's a cognizable offence, it's a non-bailable offence. So, this person will be in jail for a period of minimum 3 years and maximum of 10 years, okay, under PMLA. Then, this is also, so 4 also is an easy question. So, 4, 16 marks you can get easily. Then, 5A. 5A, they are talking about two things. One is drafting resolution for appointment of MD and drafting minutes also. So, drafting resolution, drafting minutes. And third thing they are saying, in the minutes while drafting, the chairman wants to take out some defamatory matters. Can he do that? Yes. The chairman has a right to take out the defamatory matters while signing the minutes. Defamatory matters means what? Some abused words has been used against some other person. Yes, chairman is having a right to take out the defamatory matters. That is also possible. Now, drafting a resolution is easy for MD under section 196, read with 203. So, resolved that Mr. So-and-so person, okay, is be and hereby appointed as managing director with so-and-so remuneration under section 197. You can pass a resolution, but they are asking to draft a minutes. Minutes drafting is not in your final syllabus, but it's there in your inter syllabus. Inter law you are having the minutes. So they are asking that, and it is given 8 marks. So you have to write the provision, you have to draft a resolution, and you have to draft a minutes, and you have to write that chairman has a right to take out the defamatory matters. So it's a tricky question. So according to me, it's difficult to score here. So minutes for MD. This is a difficult question according to me. So people who know this also may not get a high marks because minutes has been asked, which it's very difficult. Means like you forgot, no, whatever IPC you studied generally. Then 5B, company went into public issue rupees 200 crores for a project, out of which 30 crores they want to divert it to other purpose. See, this is exit option. If the company is going to divert, okay, so they are not spending more than 75% in the issue. So you should calculate 200 crores into 75%. Okay. So what is 200 crores 75%? 150 crores. Now the company has diverted 30 crores. Okay. So the company has not diverted more than 25%. Okay. So the question is, they have diverted 30 crores. Now you have to pass a special resolution. First of all, special resolution has to be passed. So if they want to divert, they have to pass special resolution. And if more than 10% of the shareholders dissenting it, more than 10%, then you have to give exit option for them. Exit option. So 10% shareholder, you have to give exit option. If it is given, then it is not a problem. So special resolution and exit option for the shareholders who are dissenting. So it's a fairly not difficult question. Then explain notwithstanding and without prejudice. Now, notwithstanding and without prejudice is interpretation of statute. Notwithstanding means it's a non-obstante clause. So that means this clause means this section overrides other section. So the word used is non-obstante and overrides. These two you should answer. In other case, without prejudice. Without prejudice means it's a less sounding clause. Okay, that means you have to read some other section, and without affecting this other section, you follow this section. Okay, so Companies Act is applicable to special companies like insurance company, banking companies without prejudice. That means whatever they are having, first to follow that. If they are silent, come here. So, and save as otherwise also. In section 186, 185 we will be studying save as otherwise. That means you have to follow limit 186, but whether you can give or not, you can follow 185. So that examples you should give. Then, so it is also a fairly not difficult question only. Then articles of association permits for alternate director. Can a director appoint alternate director? This is the question. Articles of association permits directors. Okay, no problem. Section 161 subsection 2. Okay. AOA permits, so alternate director can be appointed. But who can be appointed as alternate director? A person, if he is appointed by the board of directors or if he is appointed by the general meeting, can be appointed as alternate director. So a director who is going abroad, that person cannot appoint alternate director. Understood? So that question it is tested here. It's a very easy question. Then bank which is financed the company wants to appoint nominee director. Nominee director can be appointed in case the central government, state government or finance institution holding shares in the company, or if the bank has financed the company, they have to enter into an agreement. In that agreement, there should be a condition that we are going to appoint a director for you. If there is no agreement entered into like that, the bank cannot appoint a nominee director. So that is the case. Then notice is served, okay, for a board meeting 2 weeks prior, but it does not contain agenda. According to section 173, 7 days notice should be there. Correct? 7 days notice should be given. And according to standards, secretarial standards, agenda is compulsory. Correct? So under section 118, secretarial standards is compulsory. So agenda is compulsory. So the director should send the agenda. Otherwise, the person who is in charge for sending the notice, that is the company secretary or any other director, they will be penalized. If since there is no agenda, the notice will become invalid. Okay? That is the answer for this. Then, this is also easy question. Company wants to call board meeting at a shorter notice. Through video conferencing they want to conduct. Now tell me, what is the minimum day notice? 7 days notice. Okay? Then, if they want to conduct a shorter notice board meeting, at least one independent director has to participate. If the independent director is not participating, then what will happen? If the independent director is not participating, he has to ratify at least. If he is not ratifying, then the meeting is said to be invalid. So that is the answer for this question. It's a fairly easy question. Then, company's net worth is 650 crores. Explain CSR questions. That is the question they have asked. 650 crores net worth. Now, first question. Generally, out of the total profits, they earned 35% from Indian operation and 65% from foreign operation. So you should take only 35% Indian operation as the CSR computation. So only Indian income, Indian profit can be counted for CSR. Correct? So under section 135, 2% of the average net profit of past 3 years, okay, to be spent for CSR. So only for Indian operation you should select. Point number 1. Point number 2. What is the next question? For past 3 years, Indian operation is loss. For past 3 years, Indian operation is loss. See, if the company is having a net worth 500 crores or more, the company has to set up CSR committee. So CSR committee should be set up. But if the past 3 years, if the company is incurring loss and the average of past 3 years, Indian operations in loss, the company need not spend anything according to me. So Indian operations in loss, foreign income should not be included there. So the company need not spend anything for CSR expense. That is the question. Net profit of the company is 7 crores. Traveling expenses to abroad is 2.5 crores. Now, expenses of foreign has to be reduced. So, foreign income has to be reduced and foreign expense has to be reduced. Now, see, if it's a normal course of business, see, foreign CSR expenses will not be considered as CSR. But this question they are talking about, there is a loss in the last 3 years. So according to me, means like Indian operation loss in last 3 years, according to me CSR itself not applicable. But again there is a confusion. Net profit 7 crore they are giving. So if this net profit 7 crores is entirely because of the foreign operation, so it's unnecessary to answer this question. But I don't know what they are expecting from this question, because they are already given loss in the previous line. So you can answer differently also. So you have to reduce from the 7.7 crores, 2.5 crores, you can reduce like that also you can answer. But it's a current year's profit, net profit. Always you should see last 3 years only for calculating CSR. So it's, I don't know what they are expecting. It's like our competition commission question here. Maybe, I don't know whether I have not studied the question properly or there is a drafting error in this question, I don't know. Then the last session in this same question, current year the company has spent only 1.10% of the average net profit of past 3 years. See, they already told the average net profit is 0 in last 3 years of the Indian operation. So that is the case. Then you can write like that, minimum they have to spend 2%. So they have not spent that, you can write that. So this is like the confusion. So CSR, it's not so easy. CSR question, it's not so easy here. And they have given just 4 marks, it's not 8 marks. This many questions they asked and they have given only 4 marks. So you will not lose much even if you write a little wrong answer. Then straight question they have asked, option in security, spot delivery contract. Option in security is what? We have, say, buy option, okay, that is a call option, and put option, right to buy and right to sell. You have to write that. So right to buy at future date at a predetermined price, right to sell at a future date at a predetermined price. And spot delivery contract, the purchase and sale, delivery and payment will happen on the same day or within next 2 days. That is called spot delivery contract. So with this 6th question is over. Then we will go to 7th question. Few shareholders became shareholders with the condition entered into an agreement with the promoters. But those conditions never fulfilled by the promoters. But the company went into liquidation, or the shareholders liable to contribute. See, this question is from winding up whether they are contributory or not. Once a person purchases shares, they are contributory only. If they are not going to give the amount, then it's like breaching the contract. Okay, it's a IPCC portion. In IPCC portion, the company, even the subscriber who didn't got allotment of shares, okay, it's a Hansraj. There is one case line IPCC. Hansraj case is there in share capital chapter. So a person who has subscribed for the shares, but company subsequently went into liquidation, so he didn't even get the shares, but agreement has been entered, so he has to pay for the amount. So that question it is. So maybe if you read the winding up, it's a logical question according to me. It's not from winding up and all. So means like logical. So it can be answered logically. Next, liquidator expenses 10,000 rupees, secured creditor 3 lakh rupees, workman due 1 lakh rupees, and the company how to share the expenses of liquidator. So what you should do? It is 10,000 rupees into 3 lakh divided by 4 lakh and 10,000 rupees into 1 lakh divided by 4 lakh. This is the ratio you will be sharing the expense of the liquidator. Okay, this is secured creditor. Okay, this amount you will be sharing, and workman due, this amount you will be sharing. This is a very easy question only. Can a person of 62 years of age appointed as technical member in NCLT? NCLT technical member will be maximum age is 65 years. So he can be appointed for a period of 3 years. Then 7C, explain validity of the petition filed to NCLT. In the operation mismanagement question, can a shareholder holding 20% file an application? Yes, shareholder holding even 10% can file an application. So 20% no problem. Question number 2, whether non-declaration of dividend amounts to oppression. Non-declaration of dividend does not amount to oppression. Question number 3, loss incurred by the company due to mismanagement by the directors. Yes, if the, see, it's a case to case basis. It's not always just current year's loss, it is mismanagement. If it is proved it's mismanagement, they can file a case. Yes, they have to prove. Then various act of illegal, invalid, irregular transaction has been entered in the name of the company. Hence, it's also oppression mismanagement. So, complaint has been lodged under section 244. The tribunal can take the action under section 242. That's how you should answer and close the question. Then 7D, during the meeting arranged for the compromise and arrangement. This is compromise and arrangement. Then the members sell to decide the portion of the plant and pay the wages and taxes and loans. So for this purpose, they have to pass a resolution, compromise and arrangement. What resolution they should pass? Special majority. Majority in numbers holding 3/14 value. Once they pass this kind of resolution, it is valid. Then unsecured creditors will forego 60% of their dues and rest will be allotted with debentures. So there are two types of resolution to be passed. One is member resolution, another one is creditor resolution. So any objection if they want to raise 10% value, they can raise the objection. Okay. Then so this is a fairly easy question only. This resolution only they are asking. Then the last question: what are the steps for enforcing security interest? So for enforcing security interest, point number 1, the asset should be NPA. Point number 2, they should have given a notice under SARFAESI. Point number 3, 60 days time limit should be given. Point number 4, you should ask all the debtors, the company's debtor, to pay the amount to the bank. And point number 5, if the amount is not enough, then you can secure the portion of the assets which is getting secured with you. If the asset is also not enough, then you can ask that the guarantee, you can enforce the guarantee, the person who has given guarantee, you can ask that person to pay off the money to you. This is what enforcement of security interest, and the company cannot able to sell off those assets which has been enforced. Means like once it is given to you, they cannot able to sell the assets. So this is the overall picture of the May 17 exam. So I cannot tell it's a very easy paper. At the same time, it's not so difficult paper because there are difficulties. Approximately I can tell you. So this 4 marks is difficult, and this 8 marks is difficult. This 4 I can say 2 marks, and here it's also MD, it's appointment MD, etc. So another 2 marks is difficult. So I can tell 14, 15, 16 marks. So it's very difficult to answer 16 marks. Okay. And which question could have been left in choice? So if you leave the 5th question in choice, so you could have avoided this 8 marks problem. So if you could have left the 5th question in choice, so that means only 8 marks is the tough portion. 8 marks is the tough portion here, I can say. So any person who left the 5th question in choice, and out of the 7th question, if you are confused with NCLT, that is operational mismanagement, you could have left in choice, or you could have left the winding up question in choice. So either of the question, according to me, 7C, that operational mismanagement question, if you left in choice, because there is little confusion, or if the operational mismanagement, if you find easy, if you felt that NCLT you didn't study because it's the latest portion, NCLT if you didn't study, that question could have been went off for choice. And this 7D, compromise and arrangement, if you could have not, means like sir I studied NCLT also, but compromise arrangement I don't know how to answer perfectly, that is majority, the special majority I don't know, that could have been meant for choice. So according to me the question paper is a little tricky, so it's not so easy and all, and the maximum loss is say 8 marks. So out of 100 marks, 8 marks is the loss. So 92 marks, a person can attend 92 marks, and normal loss obviously some 10 marks will be there, 10 to 15 marks normal loss. So any person can expect, okay, any person who is expecting 80, so they are very good. That means 80 the person who studied properly, he can expect 80 in this paper according to me. So this is what this, and weightage wise if you see, books of accounts is 4 marks, and director chapters, I am saying like 1 A, B, C, etc. So directors another 4 marks, then again directors 4 marks, then competition 4 marks, then SEBI 4 marks, dividend 8 marks, SEBI 4 marks, dividend 8 marks, then penalty is 4 marks, penalty 4 marks, then FEMA 4 marks, FEMA 4 marks, then managerial remuneration 8 marks, managerial remuneration 8 marks, then penalties again 4 marks, penalties again 4 marks. So see here also penalty, here also penalty, and according to me directors, meetings, managerial remuneration all are one chapter, no, 1, 2, again 3, then banking 4 marks, inspection 4 marks, banking 4 marks, inspection 4 marks, inspection is 8 marks, then 2 inspections there, so inspection is 8 marks. Then directors, again 4 marks they have asked, directors, and PMLA 4 marks, directors 4 marks, PMLA 4 marks, then meetings again 8 marks, meetings 8 marks, then SEBI 4 marks, so SEBI already we have one SEBI and another SEBI 4 marks, and we have interpretation 4 marks, again directors 4 marks, interpretation 4 marks, again directors 4 marks. Then we have meetings again 4 marks, books 4 marks, meetings 4 marks, books 4 marks. So books, okay. Then SCRA 4 marks, winding up 4 marks, SCRA 4 marks, winding up 4 marks. Then NCLT 4 marks, oppression 4 marks, compromise 4 marks. NCLT, oppression, compromise. Okay. So what they have not asked, producer company is 0 weightage. Last May producer company 12 marks weightage. This May producer company 0 weightage. Okay. And what they have not touched in insurance IRDA, this they have not touched, 0 mark. Okay. So in Companies Act chapter, if you go by order, first we have dividend. So dividend we have how much marks? 8 marks. Okay. Then we have books of accounts. So dividend dividend 8 marks. Books of accounts how much marks? 4 plus 4, 8 marks. Then directors meeting plus remuneration, put together how much? 4 plus 4, 8, 8 plus 8, 16, 16, 20, 28, 28 plus 8. So 36 marks they have asked. 36 marks, it's too high, because generally 32 marks they will ask. They ask one more extra question here, 36 marks they asked. Then directors meeting become, then we have what? Inspection investigation chapter, that is 8 marks. So after inspection investigation we have 2 to 3, this one, operation risk management. Okay, so operation risk management 4 marks, then compromise and arrangement 4 marks. Yes, operation, compromise. Okay. Then what we had, companies capable of being registered under that, we have one chapter they have not asked. Winding up they have how much? 4 marks they asked for winding up. Then company capable of being registered under that, 0. Foreign company 0. Foreign company. But we can mention that foreign company amalgamation, but amalgamation of foreign company is not there. Compromise and totally different. Okay. So foreign company they have not touched here. Then government company report. There is another chapter called government company report, 394, 395. They have not touched that. Then ROC chapter. There is another 10 section in ROC chapter. ROC chapter they have not touched it. 396 to 405 and NIDI 406 they have not touched it. Then NCLT chapter they have touched. Yes, 4 marks. So NCLT 4 marks they have touched. Then special court they have not touched it. Special court they have not touched it. So special court actually generally they will have 4 marks, they have not touched here. Instead they have asked 2 questions from penalty chapter itself. So penalties, if you see how much penalty questions they have asked, 1 and 2, 8 marks they asked from penalty. Okay. So penalty chapter has been given high weightage. So this is what from the corporate law. Then from the allied law, SEBI, yes, SEBI always 8 marks will be there. So SEBI 8 marks, SCRA 4 marks is there. So SEBI, SCRA, FEMA always on 4 marks will be there. Then FEMA here also 4 marks. Then competition 4 marks will be there generally, 4 marks. Then banking, yes, 4 marks we have. SARFASI, this either any question is asked from SARFASI? No, SARFASI has not been asked. But yeah, SARFASI asked us. They asked us SARFASI question. Yes. Last question is surface. So last question is surface. So surface they asked. So surface. PMLA also they asked 4 marks. Then what are the other? They asked interpretation of statute. Interpretation of statute they asked for 4 marks. So what is missed? 2 things is missed: insurance and IRDA. They have missed it. So this is what they have missed in this examination. Producer company they have missed, insurance IRDA they missed, foreign company they missed, government company they missed, ROC they missed, and special code they missed. So overall they have touched almost everything, but the more weightage is given for directors meeting chapter. I think they could have reduced here something and they have given somewhere in this area. So this is what the analysis is. Okay, all the best.